Lady, my Lord, I appear for the Solicitor General to make the application for permission to refer this sentence as being unduly lenient, and at the same time I appear for the respondent Crown Prosecution Service in relation to the application for leave to refer the sentence as being manifestly excessive. Mr. Bhatia, King's Counsel, Mr. Varley appear for the offender here, as they did in the court below. Dealing with the reference first, it's a short point that we seek to make, but no less an important one. And can I just make the court aware, as the court knows, there are various family members in attendance today. They know perfectly well, the members of the court have considered all of the papers in this case, and they know perfectly well that there's no benefit to me in repeating the facts because they are well known. I intend to make the submission that I do based upon the learned judge's approach to the definitive guideline for adult offenders. We recognise the learned judge, of course, heard the trial. He was well placed to make factual findings, as he did, about the case drawn from the evidence that he'd heard. There are two factual findings in particular that he did make. Again, I know the court is aware of this, but for those who are listening, can I just refer to page 38 of the transcript of the sentencing hearing, and it's two comments in particular from his lordship at lines C and D. And he was explaining to the offender what he considered the factual basis for the sentence should be. And in terms of the offender's culpability for the victim's death, he went on to express two different conclusions. The first, quote, "I'm also sure that your intention, albeit for a short time when you lost your temper, was to cause the victim injuries that, although not so serious as to need hospital treatment, were bound to be close." And the second, "I'm also sure that it ought to have been obvious to you that whatever you intended, there was a high risk that what you did to an 80-year-old man would cause him really serious injury." We accept, of course, that the learned judge was perfectly entitled to reach those conclusions, but having done so in our submission, they have a significant effect on the approach to sentence that follows thereafter. The learned judge did, and again was entitled to form the view that the offender's case was so serious that a custodial sentence was inevitable, and in order to decide on the appropriate length of that sentence, the learned judge again was perfectly entitled to have regard to the adult sentencing guideline for unlawful act manslaughter. As the members of the court are aware, as culpability is the primary determinant both of the starting point and the category range, and for the purposes of that guideline, culpability falls into one of four groups, either very high, high, medium, or lower. Now, in this case, the learned judge was of the view that it was a high culpability case, and in reaching that conclusion, he referred to the two matters that we've quoted from his sentencing remarks. Namely, we submit that death was caused in the course of an unlawful act which involved an intention by this offender to cause harm falling just short of really serious harm, and secondly, that death was caused in the course of an unlawful act which carried a high risk of death or GBH, which was or ought to have been obvious to the offender. Now, we appreciate the learned judge did not say a high risk of death, but he did say a high risk of really serious harm.
Well, can I just ask you about that, Mr. Jarvis? And it's in relation to the subjective intent and the words that you've read out. "I'm sure that you punched him, his neck was broken in the fall, and that you then repeatedly kicked him hard in the ribs. I'm also sure that your intention, albeit for a short time when you lost your temper, was to cause Mr. Kohli injuries that, although not so serious as to need hospital treatment, were bound to be close." Now, in the written reference, you adopt a shorthand form for that. But this has to be contrasted, does it not, with the findings of the judge in relation to the objective assessment of the situation, where he uses the words would cause really serious injury. Now, isn't there an ambiguity about that first finding as to the subjective intent?
We submit there isn't, my lady. What the learned judge is saying, although I'm not suggesting it could not have been expressed more clearly, is that for a short period of time while in temper, the offender had the intention not to cause the victim injuries that would be so serious as to need hospital treatment, but the intention to cause the victim injuries that were bound to be close to injuries of the type that would require hospital treatment. In other words, intending to cause injuries that would be close to really serious harm on the basis that really serious harm would require hospital treatment, whereas non-really serious harm would not.
Well, that's the problem, isn't it, Mr. Jarvis? Because there are injuries that do require hospital treatment that would not be classified as grievous bodily harm or really serious injury. And it's the, as I say, it's the juxtaposition of the judge's comments. But do you have anything further that you can assist with on that point?
Perhaps if I can frame it this way, my lady, his lordship is clearly, we submit, considering the high culpability factors in this course of the remarks. And we say that's obvious just because of the nature of the comments which his lordship makes and his ultimate determination as to where it falls within culpability. And it would seem that that first quoted passage is his lordship's consideration of the first bullet point in high culpability B. And there would have been no need to have mentioned it unless his lordship was of the view that this is a case where the intention of the offender was to cause harm falling just short of really serious harm, which is why his lordship expressed himself, we suggest, in the terms in which he did, and then went on to look at the second bullet point and the question of the objective harm and the obvious risk of GBH as a consequence of what the offender was doing.
But when he's looking at the subjective intent, this is a necessary prerequisite of Category 3 culpability, isn't it? Where the judge has to form a view as to what the subjective intent was and whether it falls at an intermediate stage.
Well, it does require the learned judge to reflect on what was in the offender's mind at the time the conduct was taking place. In other words, what type of harm did he intend?
Yes.
And there's a broad range between very little harm through to harm that falls just short of being really serious harm. And the answer to that question might ultimately determine on the facts of a different case whether the court is dealing with lower, medium or high culpability. But in terms of what the learned judge said as against what he meant, then in our submission it's reasonably clear from the words that were used that he was conveying the impression that he'd formed from the evidence he'd heard that this was a situation where what the offender intended to do to the victim was to cause harm falling just short of really serious harm, thereby qualifying under Category B by reference to the first bullet point, and regardless of the conclusions that he then reached a moment later in relation to the obvious risk of what could happen to the victim as a consequence of the infliction of the unlawful force that he employed.
But whatever his conclusion about the subjective intent, he could still have come to the conclusion he did about the objective assessment of the situation, which would still have rendered it high culpability.
My lady, that's true. And we rely on what Lady Justice McCurr said in Parry about the relationship between those two different factors. And so, not trying to be mechanistic about it, because it really isn't that type of case. In fact, these cases aren't mechanistic at all. This is an application of the learned judge's judgment. But the point that this court was making in the Parry case is that those two considerations are quite different one from the other. That on the facts of a particular case, it might be that an offender formed an intent to cause harm just short of really serious harm, but in circumstances where there was no objective risk of that serious harm coming to pass, or vice versa. So an objective that there was an intention to cause serious harm or something approaching it, but in the absence of objective risk of that arising. And so...
Well, the difference in Parry, speaking from some experience of the case,
Indeed.
Mr. Jarvis, is that the facts were such that the objective assessment of what went on in an act of vigilantism was that there was an objectively the prospect of death, even though the subjective intent was to do grievous bodily harm.
Indeed, my lady made it very clear, and can I say I'm not relying on Parry because I'm trying to tease out factual similarities. We're trying to identify the principle and see how it applies to the facts of this case. But I recognise the point the learned friend makes in his written submissions that unlike Parry, where there was an obvious risk of death, that wasn't the conclusion the learned judge came to here.
No.
And I'm not, I make it clear, inviting this court to reach any contrary conclusion. I base my submissions entirely upon the conclusions which the learned judge himself reached. But the point we do say that emerges clearly from Parry is that these are not, to use my lady's expression, two sides of the same coin. In other words, where both are present, we submit that must increase the seriousness of the offence.
Well, I think that's actually mechanistic, isn't it, Mr. Jarvis? If you just say because they're both present, they're always going to be both present. It's where they fall in the balance and the weight.
Well, they may not be both present, my lady, depending on the facts of the case, but where they are both present, because they are both separately identified high culpability factors.
Well, hang on a second. How can you not have both a subjective element and an objective element?
Well, you can have
They may be different in different grades, but...
No, I understand that, but in terms of the subjective element necessary to meet the first bullet point in B and the objective element necessary to meet the first bullet point in B.
But this is part of the discussion, Mr. Jarvis, that you could have a different categorisation if you were looking at subjective and if you were looking at objective.
Yes, and my lady, we entirely accept you might have a situation where the subjective element gets you into category B, but the objective one is in C, for example. Or A.
Yes.
Well, or anywhere else within
Yes.
the guideline. Of course, that's true. So we're not suggesting that there will never be an objective element just because there's a subjective one. But in terms of high culpability B, the guidelines are quite specific about what the subjective and the objective components are.
Yes.
And where both of those are present, in other words, both high culpability subjective and objective factors are present, as the learned judge has found, then in our submission it isn't mechanistic to say that has to have an effect on the sentence. So if one of them were present and the other one were not and fell into C or D, for example, then the court obviously has to undertake an evaluation of where within the A, B, C, D culpability matrix the facts fall. Here there were two distinct high culpability factors that were present, the objective and the subjective, on the facts as found by the learned judge. And the question then would become, what, if any, effect should that have on the sentence to be imposed? Now, the guideline itself hints at what one possible effect is, in where it says where there are a combination of culpability B factors, that may move the sentence into very high culpability. And again, it would be mechanistic for me to say, well, the presence of both of those factors inevitably must have had that outcome, because the guideline itself says it may or may not do, matter entirely for the judge. But even if the learned judge was entitled in this case to conclude that the presence of both high culpability factors did not mandate the placement of the case into the very high culpability bracket, we submit that it must have had some impact on the approach of the court to sentence. In other words, it must have had the consequence of requiring the learned judge to look again at the guideline and decide whether those two factors in combination, even if not justifying the movement into very high culpability, does justify the movement up from the starting point for a high culpability case. And that did not happen, and we submit, when looking at an authority like Parry, all the Court of Appeal is inviting sentencing judges to do is to reflect carefully on whether the presence within the same bracket of the subjective and the objective factor has that effect or might have that effect. And in this case, I'm not suggesting that the only possibility would have been a movement into very high culpability, because it would have been a matter for the learned judge, and because he didn't find that there was an objectively high risk of death, that might very well be a good reason not to move into the very high culpability bracket because it was only an objective risk of really serious harm. But the presence of both in our submission ought to have meant a movement from the starting point upwards before the learned judge reflected on the extent to which any further adjustment was needed for the resolution of aggravating and mitigating factors. And had that been done, and we don't criticise the learned judge's decision that there needed to be an upward movement of 2 years from wherever he ended up before he undertook that exercise to reflect the aggravating and mitigating factors, and in particular the use of the language which the offender employed against the victim, that we do not criticise. That is an increase that ought to have been made from a higher point than one of 12 years, being the starting point for an adult at high culpability, and should have been 2 years added to a longer figure than that to reflect the matter that we've sought to develop in the course of our submissions. There's no criticism either at all in the learned judge's decision that that sentence, notional as it was, needed to be reduced by 50% to reflect the offender's age at the relevant time. So that, again, sounds mathematical, but of course it's not, because the court knows exactly where that comes from. It's not simply a case of 50%, it's an assessment of youth, maturity, personal circumstances, and the learned judge, we submit, was entitled to do it. But all of those calculations should have been applied to a longer term notionally than 12 years, bearing in mind the presence, as we submit, of 2 high culpability factors which must have had an impact on the overall sentence to be imposed in this tragic case. That is the short submission that we seek to make about why we say it's an unduly lenient sentence. If the courts against us, my ladies, my lord, conclude that it was not unduly lenient, we submit that it most certainly was not manifestly excessive. For the reasons being, the learned judge was perfectly entitled to find that custody was inevitable. Having reached that conclusion, he was perfectly entitled to apply the definitive guideline, which he did. That there can be no argument, we submit, with his conclusion that high culpability was the correct starting point. And he made appropriate adjustments as he saw it for matters of mitigation and aggravation, and set them out in some considerable detail in the course of his sentencing remarks. And that's how he reached the ultimate sentence for an adult offender of 14 years and applied what we submit was an appropriate discount for youth. And so while there are submissions made about, well, should he have attached less weight to matters of aggravation or more weight to matters of mitigation, we submit the learned judge carried out that part of the sentencing exercise in an exemplary fashion, and there's no complaint that we submit that can be properly made about that part of the sentencing remarks. So we say, if not unduly lenient, most certainly we submit not manifestly excessive.
A question, if I may, Mr. Jarvis. It was the prosecution who invited the judge to reconvene and clarify a point of sentence.
Yes.
Do you want to make any submissions about that at all? This is relating to the racial aggravation.
Yes. As far as we know, that was undertaken by, as my lady says, Crown Prosecution Service at the court, because by statute the learned judge was required to identify the portion of the sentence referable to the element of racial aggravation which he'd found present on the basis of the language employed by the offender towards the victim at the relevant time. So it wasn't, as my lady has said, an adjustment to the length of the sentence. It was simply a recalibration by the learned judge of the approach that he'd taken. And in other words, again, for the record, that the 2-year increase from the starting point, a year of that was attributable to that racial component that he'd identified. And we don't criticise the learned judge for that approach.
Thank you very much, Mr. Jarvis. Bartia.
My ladies, my lord, my first request, my lady, is if your ladyship would just adjust her microphone slightly. I'm just having difficulty hearing. Thank you. This court, in many cases, have used a phrase, fact-specific. We submit that that is perhaps the most important factor when applying any sentencing guidelines. fact-specific, tailored to the facts in the case. And we further submit that the guidance is absolutely plain in all of the sentencing guidelines, and as Mr. Lord Justice Singh, in the case of Parry, quite lucidly makes observations during his judgment. May I adopt those particular factors? Determining the offence category, it is worthy, we submit, of repetition of the guidance that is there. We use them so often in courts that there is an element, sadly, of perhaps being overly mechanistic in the application. But if we go back to the guidance in determining the offence category, I'll read it out. The characteristics set out below are indications of the level of culpability that may, I emphasize the word may, attach to the offender's conduct. The court should balance these characteristics to reach a fair assessment of the offender's overall culpability in the context of the circumstances of the offence. Fact-specific, my words. The court should avoid an overly mechanistic application of these factors. Lord Justice Singh in Parry went on to say, under the heading A, this is obviously referring to the manslaughter sentencing guidelines, A, very high culpability, the guidelines continue. Very high culpability may, in bold letters, may be indicated by the extreme character of one or more culpability or a combination of culpability factors in category B. Can I take an example? And your ladyship will be familiar. The extreme character of one or more of those culpabilities. In relation to the case of Parry, it was plain, just by the head note alone in relation to the two competing factions, the Red Chiefs and the Bandidos, affiliations to Hell's Angels, chapters, the use of the van as a weapon, a ton or so of metal hurtling at 20 miles an hour, deliberately ramming a motorcycle where the deceased was dislodged, fell underneath that van and dragged for nearly 1,000 meters. Obvious risk of death. There's a significant distinction in those particular facts. Even in Parry, 47 fractures to an 11-week-old baby, 3 caused by blunt trauma in relation to the skull fractures. All of those are factors which, on those two authorities, were properly utilised by, certainly in Parry, the sentencing judge, in coming to their conclusions. If we have a look in relation to really the gravamen of this assertion by the Attorney General's reference, it is really the subjective intent to harm and the objective risk of harm, and their assertion that the combination of the two should either elevate it to culpability A or certainly the higher echelons of culpability B. Your Ladyship, I beg your pardon, made the observations in Parry that, of course, there is an overlap between the two, but there is a distinction to be drawn in relation to the subjective intent and the objective risk of harm. It's rather like an eclipse. It's fact-dependent. And on the facts of this particular case, we make the following submissions. The subjective intention. we submit that the learned judge's finding on the evidence was that the offender had pushed the deceased, who fell to the ground as a result of the push. The fall caused the broken neck. My lady, medical evidence was adduced during the course of the trial, Mr. Todd in particular. Effectively, sadly, the vulnerability of the deceased neck was such that had he spent a day in his beloved allotment and fallen his length accidentally, the cause would have been the same, the result would have been the same, a broken neck. Therefore, little or no force was required. But here, we accept that as a finding of fact, as the learned judge was entitled to do, both on the effectively hearsay evidence of Bhim Kohli, namely that the boy had punched and kicked him, and also on the respondent's own text message that he had punched and lost his temper.
So what do you say, Mr. Bartier, about this issue I raised with Mr. Jarvis? Do you accept that there is or should be no ambiguous aspect to what the judge found as to subjective intent?
It's difficult because certainly the learned judge made reference to both of the limbs in category B, that is the subjective and the objective element. That is plain from his sentencing remarks. But it's also plain that in terms of really serious injury, and we practitioners often get a note from the jury, can we have some clarification as to what really serious injury means? Because, of course, there's no definitive legal definition, there's no legislative definition, and therefore there's always going to be a range of injuries. And the range of injuries here, we submit, are at the very lower end of what may be regarded as really serious injuries.
Yes, but that's a different point with respect, Mr. Bartier. The judge was telling this offender, this applicant, why it was he was going to sentence him in the way that he did. And he made two findings, as Mr. Jarvis has said, one relating to subjective intent and one relating to objective intent, assessment of risk.
Yes.
So on the objective assessment of risk, the words of the sentencing remarks are plain, that objectively anyone with a view of what had happened would think, in common parlance, there's going to be something really serious happening here, because Mr. Kohli was an elderly man, fragile, as the judge described him. And there may be reports, and there are, of course, reports, Mr. Todd's report, referring to a vulnerability because of the osteoporosis and because of a previous fracture to the lumbar spine. But what do the judge's remarks mean? Do you accept Mr. Jarvis's point that we should take them as saying, in effect, you intended, albeit for a short period of time, to cause really serious injury?
I believe the words he used in his sentencing remark was that I am satisfied that this is a culpability B category.
That doesn't answer the question, Mr. Bartier, sorry. It goes to the point that the Solicitor General is making, which is that if he finds two high culpability factors, so the subjective intent and the objective assessment, it's one of the things that he should have contemplated in moving it up, either to another category, the very highest, or up the range. Now, it's the words that he used that are of some interest here as to whether or not they're ambiguous or not.
Well, they must be ambiguous because it's plain that he uses the word so serious as to may need hospitalisation. So we say that they are ambiguous, and it is difficult to ascertain whether the learned judge properly addressed the issue of whether the really serious injury. But on the facts of this case, we submit that the actions and the injuries were of such a level, and we submitted that really this was a category C during the submissions in mitigation.
But you don't maintain that. You don't maintain that.
No, we accept that whichever way you look at it, the facts of the case perfectly justify the learned judge to come to a conclusion this was a culpability B. But of course, the category range in relation to culpability B, starting point is 12 years, but the category range is 8 to 16. The whole point of category ranges, my lady, of course, is to give flexibility to the facts of the case. And we submit that just given the two authorities that have been cited, there is a huge distinction on the facts of the case that we're dealing with. And we submit not only that the combination of the subjective and the objective risk here, when it's looked at and analysed properly, we submit it would not take it out of category B, but we submit it would bring it lower within category B when looking and comparing the authorities that have been cited in the Attorney General's reference, namely Parry and Prajapati. So we submit that the starting point, and this really perhaps allows me to go on to the submissions in relation to the appeal against sentence, but can I, just before I leave the response in relation to the reference, again invite reference to the case of Prajapati, where reference was made by Lord Justice Singh in relation to the following. In giving the judgment of this court in the seminal case of the Attorney General's reference number 4 of 1989, citation given, Lord Lane, Chief Justice, that even where this court considers that a sentence was unduly lenient, it has a discretion as to whether to exercise its powers. It also emphasised, as this court has done ever since, that its role is not simply to retake the sentencing decision as if it were the sentencing court, and that mercy is a virtue does not necessarily mean that a sentence was unduly lenient. How we submit with some force that this is not a question of discretion. On the facts of this particular case, it fell mid to low range culpability at its highest. In terms of having made that concession, in terms of the appeal against sentence, can I just address the court in relation to two factors? The first we submit is that the starting point of 12 years was too high. The second point we submit in relation to the aggravating and the mitigating factors, both having been taken into account, which resulted in the addition of 2 years, making a total, had he been an adult, of 14 years, no issue taken, of course, in terms of the application of the Children and Young Person Sentencing Guidelines and the reduction of 50%. He was under 14, albeit very close to 15 at the time. Your Ladyship asked in relation to clarification. The learned judge quite rightly found that a racial slur by, I'll call him now the applicant, since I'm making submissions in relation to the appeal against sentence. that although he considered it to be a lazy insult, it was nevertheless a hurtful one. I wholeheartedly agree. It was a hurtful insult. On the facts and on the enunciation of that word in the context was whether that justified an upward adjustment of 12 months is, we submit, manifestly excessive. I don't take it in isolation and try and compare it with racially aggravated offences. I take it within the context of this case, which of course gives it greater weight, greater substance, because of the tragedy that followed. But even having made that concession, taken those factors into account, we submit that that factor in itself was not capable of justifying a significant upward adjustment. In terms of the aggravating factors, I have dealt with the racial allegation described by the learned judge as a lazy but very hurtful insult. There was, we accept, very severe pain from the broken neck. Live footage was seen of those injuries. It is, with respect, never an easy aggravating feature to fully understand, but within the context of this case, although some recognition of that factor is to be given, it is not the sort of case where we are dealing with, for example, torture before death and the like, and therefore some weight, of course, needs to be given to it, but it needs, we submit, to be kept in perspective, again, fact-specific to the case. His Lordship further found that, of course, Mr. Kohli was vulnerable because of his age, but he was keen to and did point out that he was aware of double counting on that particular aspect. I take that matter no further. Recognition is made of that. There were two separate incidents, and therefore an aggravating feature in relation to what was described as an ongoing incident. And in one respect it was, but there were two separate incidents. The first, quite rightly described as wicked, the pushing of Mr. Kohli, deceased, onto the ground, and the use of a slider to slap him across the face. There was then disengagement from that particular incident when the applicant walked away. And it's also plain at that stage that Mr. Kohli followed in justifiable anger, and therefore incident 2 was a reaction, unlawful reaction, of which he was convicted in relation to manslaughter. In terms of mitigating factors, they were the following: no previous convictions, doing very well in relation to his time in custody, applying himself to a number of courses, educating himself, taking on apprenticeship for bricklaying, and receiving a vast number of awards and certificates. Issues with his mental health were well documented in the pre-sentence reports. I do not go into those in any more detail, and it's plain that his background and his life at home for the 14 years or so that he'd been there had been a significantly disadvantaged one, and again, I won't go into details, they were raised. So we submit, my lady, just two submissions in relation to the appeal against sentence. On a fact-specific basis, the starting point was too high, and the aggravating factors that were there did not justify a 2-year upward adjustment. I started off with the phrase fact-specific. I finish with the same phrase, fact-specific, tailored to the facts of this particular case. My lady, can I assist any further?
No, thank you very much. Because of the time and because we'll discuss this matter, I'm sure for some time now, I'm going to say that we will sit again not before 2:10.
Thank you, my lady.
And hopefully by that stage we will be in a position to give judgment. So 2:10, please.
We leave our robes in here.